Good day, Crime Talk aficionados. It is December 4th, 2021. It's a Saturday. So what does that mean? That's right. It is the weekly highlights throughout the week from Crime Talk. Thanks for watching. Today is Monday, November 29th, 2021. Let's get to the docket. First, the Daybell-Vallow Chad Daybell matter. Now, nothing has really taken place in this case other than, well, Daybell-Vallow is at the state hospital, hopefully being restored to competency so that she can come back and face charges. We don't have a trial date set, but we have a hearing to set a trial date. That'll take place in early December, but the trial probably won't take place until next December. Well, as you may recall, the district attorney had their motion denied as it related to the change of venue. They said, yes, we agree that the change of venue should take place. However, we believe that we should bring a jury in, basically bust them in, put them up in a hotel, and let's keep them here in Madison County. The judge says, no, we're going to move to the other side of the state. The prosecutors then filed a motion to reconsider, saying, well, Judge, we didn't really have our ducks in a row on the day that we had the hearing that we knew about. And well, we'd like to present more information regarding how really expensive this is and the cost that's going to be incurred by the taxpayers. The judge said, yeah, let's vacate that hearing that we had set for additional hearings. And he basically said, hey, listen, this trial date could be so far out, we really don't know what's going to happen. And there are orders in place that jury trials may not be able to take place because of certain COVID restrictions. And so basically what the judge said was, this isn't ripe yet, which means it's something that the judge doesn't have to consider just yet. All right. You have what is ripe and what is moot. Is it ripe? Is it really at the stage where the judge has to actually decide something? And moot means, well, it's already been decided. There's no order that needs to be made by the judge. So really what the judge says, this isn't right. And basically, we'll just wait and see as things get closer. And then you can provide me some relevant data, not something that's really going to be probably at least a year old. So the judge basically said, hey, you had your shot. I'm not going to give you a new shot, but I'll revisit it down the road. I still think the judge is going to stick by his order. Why? Because judges don't like to change their mind. It makes them look weak. It makes them look indecisive. And in this particular case, he's ruled on something. Now, if we can just get a trial date, a motions hearing date that'll be a hard date, which means we're actually going to go to hearings, then the case would finally move along. It is Tuesday, November 30th, 2021. We've got a very large docket for you today, but it is worth you sticking around for the entire thing. The first thing we want to talk about is the response filed by the prosecution in response to Mark Means' motions that he filed regarding Daybell-Vallow calling the LDS church, the Mormon church, and basically seeking counsel and things to that effect. Well, the government does not hold back on anything in their motion. Basically, they just lay it out there that Mark Means is, in using their words, not mine, it's in a motion, unethical, over the top, and basically sanctions should be imposed. It was almost as though I had written the motion because everything that they talk about, I mentioned when we talked about the motion that was filed a couple of weeks ago. And I'm telling you, a little suspicious. And I thought, where's Mr. Archibald in all this? Well, the prosecution makes note of that as well. So as you may recall, the attorney for Daybell-Vallow, Mark Means, he's kind of been there from the beginning. He filed a motion for violation of Brady violations, motions for criminal depositions, motions for out-of-state subpoenas, and motions to disqualify the Idaho Department of Health and Welfare. And I said, well, I don't think the state's violated any Brady rules. Criminal depositions are only taken when, in fact, people's deposition or when there's testimony needs to be preserved, like they're going to die. Maybe they're being in the military and they're being shipped out overseas. And then the out-of-state subpoenas. Well, the court in Idaho has no jurisdiction over anybody in Utah. Pretty much law school 101 procedure. And then the motion to disqualify the Department of Health and Welfare. Very creative indeed. And the prosecution agreed with my assessment. Maybe the prosecution's been watching CrimeTalk because I could have written this motion. Their first response in regards to the Brady material. Now remember, Brady material is anything that is exculpatory. Okay, the government, pursuant to Brady v. Maryland, it's a United States Supreme Court case in 1963, and it basically says that the suppression by the prosecution of evidence favorable to the defendant upon request is a due process violation where the evidence is material to either the guilt or innocent or punishment, irrespective of good faith and bad faith of the prosecution. What does that mean? It means the prosecution has to turn over everything, good, bad, and ugly, whether it helps their case or not, but it has to be within their control and possession. So statements that are made to a third party, the government has no obligation to go and get them. So if Lori Vallow allegedly calls the LDS Church and makes statements, those are not within the control and custody of the prosecutor. They don't report to them. If those statements were made to the police department, the prosecution should have to go and get them. But apparently in this particular case, the prosecution says, you know what, we were made aware of some statements, we turn them over immediately. And so basically they say, Mr. Means, go back to school, learn what a Brady violation is instead of just throwing out allegations. And they also say the obvious, that Mr. Means can go and talk to these individuals. And I don't know how many times we've talked about this. In the civil world, everybody wants to take depositions. In the criminal defense world, you don't get to do that. You hire an investigator, you get in your car, you go fly to see somebody, and you go knock on their door and see if they'll talk with you. And most of the time they do. But it seems as though nobody's doing any investigation like going to actually talk to these people. Now remember, every witness can say, we don't want to talk with the with either side. They basically will say, we'll see them in court, but you don't get to request depositions. And really, this is the blow that I think is quite obvious, and I mentioned this early on when Mark Means starts filing these motions. I said, where is the co-counsel? Why is he not joining in this motion? Well, the DA's kind of basically lay it out for you. He says the potential for harm to Vallow Daybell by publicizing such statements is high and could be extremely harmful to Mr. Means' former client, Chad Daybell, who is a co-defendant and alleged co-conspirator in this matter. The DA then says, it is noteworthy that Vallow/Daybell, court-appointed death sentence qualified public defender, has not joined in this motion. That's right. Mr. Archibald, the experienced criminal defense attorney, is not joining in these motions whatsoever. I would love to be a fly on the wall when Mark Means and Mr. Archibald meet. And the prosecution is not wrong. I do not know why Mark Means is still on this case. He said in open court that he not only represented Lori Vallow, but that he represented Chad Daybell. He said in open court. Why is he still on this case? I have no idea why. But he's there, and so we do that. The next argument was the depositions, and basically the prosecutors outlined for Mr. Means, go to Rule 15, and that's to depose in order to preserve testimony for trial, not just because you want to go interview somebody. Go interview them. And basically it also states that the court cannot subpoena anybody out of the state of Idaho. Simple facts, simple rules of law. Mr. Means needs to start reviewing the law before he starts filing motions. And they go on about disqualifying the Idaho Department of Health and Public Services and basically says the court is not going to get involved in doing anything along those lines. I think the prosecution is totally correct in this analysis completely. The prosecution sums up and basically says there's no evidence to support the declared motion filed by Mr. Means, that Mr. Woods has never, ever met alone and spoke with the attorney from the LDS Church. The conversation regarding this issue apparently lasted approximately 1 minute, and Mr. Wood informed the said attorney he would notify the defendant's public defender. Mr. Wood immediately contacted the defendant's court-appointed counsel and informed him of such information. And this is where it really gets good. The prosecutors say Mr. Means' continued representation of the defendant is inappropriate and unethical. Mr. Means has an unwaivable and unethical conflict of interest due to his past dual representation of both Lori Vallow and Daybell and her co-conspirator, co-defendant Chad Guy Daybell in regard to the subject matter of this case. Mr. Means' continued involvement in this case is inappropriate and creates issues for appeal. An inquiry into the conflict must be held in this case, and a knowing, intelligent waiver of conflict on the part of the defendant must be waived. Mr. Means' continued involvement in this case is inappropriate and creates issues for an appeal. An inquiry into this conflict must be held in this case, and a knowing and intelligent waiver of conflict on the part of the defendant must be made in order for Mr. Means to ethically represent Vallow Daybell. However, an inquiry and waiver cannot occur due to the defendant's restoration commitment and related stay on this case. They go on to say further, any waiver, even if knowing and intelligent, should be rejected by the court. An incompetent defendant should not be presumed to have waived the constitutional right to conflict-free counsel, especially when said counsel appears willing to publicize private statements of the defendant. At a minimum, Mr. Means should be precluded from filing any other documents in this case that are unsigned by his co-counsel until such time as the court can engage in inquiry with the defendant regarding the conflict of interest. Ouch! Ouch! This is what I have said all along. Mark Means doesn't know what the hell he is doing, in a respectful way. And I think it is clear to everyone that is familiar with the law. The DAs sound like they've finally had enough. They're pulling out the conflict card, which frankly should have been raised early on in this particular case. And I love that basically they say Mr. Means shouldn't be allowed to do anything without adult supervision in this case. Can't disagree. Cannot disagree. He's never tried a felony case. He is completely in over his head, and he should be removed from this case immediately. There you go, ladies and gentlemen. I said it. Oh, that's right. I said it, I think, a year ago when there was a conflict where he said he represented everybody. So
the amount of resources that can be saved in order to allow that to happen, and given that I represent her husband, Chad Daybell, in the event that there's an issue there.
Mr. Means, have you ever represented any of the alleged co-conspirators that are set forth in the criminal complaint?
No, Your Honor, other than Mrs. Daybell.
Not trying to say that I was correct a year ago, but, well, I think I said what everyone should have been raising before. I think they were trying to play nice. Clearly, the prosecution is done with Mr. Means, and they're going to get rid of him. He should just go away. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Next on the docket, let's talk about Josh Duggar. And for all of those that hate it, that's right, rhymes with hugger, okay? I said it. One lady wrote me a response last night that was just, how I guess just so tired of you saying Josh Duggar rhymes with hugger. So why are you doing that? Well, I think it's kind of funny because remember, he's accused of doing terrible things, possessing images. Hugger, right? Well, anyway, the judge overseeing Josh Duggar's trial ruled in favor of the government. We talked about this yesterday. The prosecution wanted to introduce what they refer to as 404B evidence. What the government seeks to introduce evidence that is both relevant and admissible under Rule 404. And the court found that the admission of this evidence at trial will not violate Rule 403. Now, what is Rule 403 under the rules of evidence? Basically, it says, Rule 403 says, hey, the evidence that the prosecution wants to introduce, although relevant. It goes to prove or disprove one of the elements of the offense charged. However, even if it's relevant, but it is so prejudicial that it outweighs the probative value, it shouldn't come in. And so what the court says is, hey, I get it. This doesn't look good for Mr. Duggar basically admitting that he did inappropriate things with other young girls, including his sister. Even though it was years ago, I'm going to allow it in. Now, I'm not the judge, and he's got to rule the way he sees it. I frankly would not have allowed it in simply for the fact to avoid any appellate issues. Why? Because now this just became an appellate issue. If their case is so strong, let the government ride on what they have. So we'll see if that has any effect. Now, yesterday, 52 potential jurors were basically sifted through the courtroom to decide who's going to be the jurors in the case. By Tuesday night, the jury had been picked. 12 jurors plus 4 alternates. Reporters weren't allowed inside the courtroom during the jury selection due to space constraints, which is not unusual. So it's kind of unclear as to who all the jurors are, but the potential jurors were screened first by the judge, then the prosecutor and the defense were allowed to ask questions, some of them relating to what is your favorite crime drama? Do you have any past trauma? Among the group was a CEO for a trade association, a retired Arkansas credit union president, a special education teacher, an operations and logistics manager at Tyson Food, as well as an online boutique owner. One woman has her own photography business, another rents out property near a lake, and a third works for a graphic design person at a nearby church, where she is a passing acquaintance of one of the Duggar's attorneys. Now, one of the jurors is a city worker that has kind of a general distrust of the government, but he did say that, if he was called as a juror, he would, be allowed to be fair and impartial. One woman was excused because she's 29 weeks pregnant with twins. Seems reasonable to me, that's for sure. And one of the jurors, his daughter is married to one of Josh Duggar's brothers. Needless to say, he was quickly dismissed. Now, the judge did do some general questioning about the familiarity with Josh and his family, and for the most part, nobody knew much of anything about the Duggars, which is good. And I've mentioned this all along. Everyone asks like everybody should know somebody just because they have a social online presence. No, most people don't. And most of these potential jurors, guess what? They sound pretty conservative. And a school teacher, that's the last person I would want on a case involving abuse of a child. Why? Because most people that go into teaching like children. Some we've talked about like children just a little too much. Not in this particular case. Wouldn't want them on, but hey, you don't always get the perfect jury pool when you're picking a jury. So we'll see how the trial goes. Unfortunately, we don't have cameras in there, but we'll give Mr. Duggar the presumption of innocence like we do everyone that has a case that has not been convicted by a jury of their peers or pled guilty in a court. So we'll continue to bring you that information as it becomes available. It is Thursday, December 2nd, 2021, and this is Crime Talk, the most fact-driven, unbiased, true crime channel. All right, let's get straight to the docket. First, Chad Daybell. Daybell-Vallow. Well, kind of, she had a hearing. It was at 1 o'clock today, Mountain Time. And what happened? Well, what happened was what happens at most hearings in front of the Honorable Judge Boyce relating to anything regarding Daybell-Vallow and Chad Daybell. A whole lot of nothing. It seemed as though, once again, nobody's really prepared to do anything. A couple of insults are thrown back and forth, and really a whole lot of nothing. Let's talk about that. First, when is there going to be a trial date? Well, basically, Mr. Wood threw out that the government would need at least another year, and they'd be ready to try this case sometime in January of 2023. 2023, ladies and gentlemen. Another year to get ready. Now, as Mr. Pryor did point out that at one point when Mr. Pryor asked for a waiver of speedy trial and a request for a continuance. The district attorney said that he was ready to go, which I've said all along. When the state files their indictment, that is their position saying we're ready to go. And if you're going to exercise your speedy trial rights, guess what? The government better be ready to go. Okay? Not happening. Where was Mark Means? Okay, he wasn't on the actual picture. The court made reference that he wasn't there, but maybe there was some reference that he was on the phone. It was very odd. But, he's the one that caused this big brouhaha about statements made by Lori Vallow, brought in issues regarding the state health mental hospital, and basically nothing got held on that matter either because the court needs to make certain decisions as it relates to can they even have a hearing when Lori Vallow is still not competent? Does she have a right to be present? And can anything really take place in regards to anything related to Lori Vallow since she is incompetent? Well, the judge wants to get the state attorneys on there. So what took place? Well, a whole lot of nothing. We set it out even farther, and everything will be subject to a future scheduling order. The case continues, draws on and on and on. Has anyone ever heard that little saying, a job expands to the amount of time given? I have. Most judges operate under that theory, okay? Set a date, set firm dates, and you better have a real good reason to ask for a continuance. And I just don't get why everyone is so afraid to go try this case. If the government needs to go try it without Lori Vallow sitting next to Chad Daybell, so be it. Go try the case. Give the man his day in court. Do it again if you have to try Lori Vallow if she's restored to competency. But you can't sit around and wait forever because guess what? At a certain point when the defendant starts demanding his speedy trial rights and you don't give him to him, they get set free on a speedy trial violation. Think about it. Guys better get going out there because somebody's going to do that. Now, one thing I do think is worth noting is that Mr. Pryor said that Lori Vallow's attorneys have had some 8 to 10 months now since this case has gone death, and they apparently haven't even started their mitigation work yet. What? That's the first thing you do on a death penalty case. Yes, you look at the facts, but you start a parallel investigation regarding mitigation, anything that will take death off the table. And for the attorneys to state that they haven't done anything, they haven't started anything yet, are you kidding me? Judge Boyce, you don't want to be Judge Ito. That's right, Judge Ito of the not so famous judge in the O.J. Simpson trial. Get a hold of this situation, Judge. You're looking, well, like you are not in control of your courtroom. And every judge knows there's one thing you have to do. Make sure it's your courtroom. Bottom line. All right, let's get to the Ghislaine Maxwell trial. Let's face it. I don't think this is going the way the prosecutors were hoping that it would. Okay, remember, Ghislaine Maxwell is charged with basically the conspiracy to basically traffic individuals for the pleasure of that guy named Jeff. Okay. Now, what have they brought so far? We've had one of the complaining witnesses testify, and apparently the words of the day were, I don't recall. That's not what I said to the government. And yes, there were lots of inconsistencies between all of her statements over the last some 20 years. What do inconsistent statements mean? It means basically you don't recall. It looks like you're making it up, and it looks like you could have memory issues, that you could be manipulated, and it could be for the money. Kind of the theory and the theme going on in the trial. That's the theory and the theme for the defense. So far, it's coming up. So the prosecution has called the former housekeeper of that man named Jess, Juan Alessi. Now, he's 72 years old, and he took the stand during Thursday's court hearing, the fourth day of the trial. Now, he was handed a 58-page household manual that was dated back to February 14th of 2005. And it had a list of things that the staff should abide by. If anyone's ever worked for somebody in this type of situation. This is not uncommon, okay? It's called the rules of the house. And let's see what are the things that the government has tried to anticipate that this will show some sort of conspiracy. First, they said that the manual says try to anticipate the needs of Mr. Epstein, Miss Maxwell, and their guests. That seems reasonable. If you're being paid to be the butler of the house, and the staff should anticipate what they're going to need. I think that's called just doing your job. Do not discuss personal problems with the guests. Seems pretty obvious. I'm surprised that even needs to be in a manual, but my guess is it's there because somebody violated that rule over the years, and they put it down in writing. Nobody cares about your problems when you're at work, okay? Unobtrusiveness is the key. And never disclose where that guy named Jeff or Miss Maxwell or their activities or their whereabouts may be to anyone. Ladies and gentlemen, that is, so far, I'm not offended in any way whatsoever. Let me know if you think you are. And then basically to summarize the testimony is that if you work for the staff there, you are to see nothing, say nothing. There are clubs, there are certain lounges people go to that's the rule of the staff. Like once you go in there, you see nothing, you say nothing. Not particularly offended, and particularly in it's a private house. Well, then one of the prosecutors, Maureen Comey, the daughter of James Comey, asked Mr. Alessi what he thought that meant, and he replied, I was supposed to be blind, deaf, and say nothing. Well, looks like he read the manual and he got it. There were questions regarding in the master bedroom. The staff were to ensure that a gun was placed in the bedside table drawer and shutters were closed. Okay, my gosh, that sounds like the Reich household at night before I go to bed. I just don't have staff to do that. Mr. Alessi also said that part of his job was to clean up after the massages that that guy named Jeff would receive. Now, apparently these were 3 times a day, and they would usually take place in the restroom of the house. And asked if they ever found anything unexpected. He said that occasionally they would find some adult toys that were in the massage area. Now, in an interview with the Palm Beach police back in 2005, Mr. Alessi admitted that he would often wash off some of these toys after young girls visited that man named Jeff for a massage. Now, the bed would have to be made a certain way after each massage, and he said that sometimes you could tell that there would be a remnants of sexual activities. Now, Mr. Alessi said that he did, in fact, remember the 2 girls during his employment with Mr. guy named Jeff, who appeared to be underage. He was then shown a photo of the first accuser in the trial, the woman identified as Jane, and confirmed that that was in fact her. The second was a photograph of Virginia Roberts, the woman who claims that the man named Jeff loaned her out to Prince Andrew. Mr. Alessi said that Jane was introduced to him by Miss Maxwell at the Palm Beach house, and that he estimated she was about 14 or 15 at the time. He explained that on Jane's visits to the house, he would pick her up, and that he recalled Miss Maxwell instructed him to chauffeur her because she didn't have a license. Now, Mr. Alessi also said he recalled driving Maxwell, that guy named Jeff, and Jane to the plane and seeing them board together. Now, Mr. Alessi then said that he recalls meeting Virginia Roberts on a trip to Donald Trump's Mar-a-Lago club with Miss Maxwell. Mr. Alessi and Miss Maxwell has visited the luxury spa in the area when Maxwell saw Roberts and told Mr. Alessi to stop the car. Alessi recalls Roberts being young and wearing a white uniform like a nurse. Apparently, Roberts had been working at the Mar-a-Lago locker room at the time and was hired to work for that man named Jeff roughly about the same time. Mr. Alessi estimates that she was probably 14 to 15 years old. When asked about the massages and how they went on, Mr. Alessi said at the beginning, when he started working there, that the guy named Jeff would receive a massage about once a day. At the end of his employment, he was receiving up to 3 massages a day, and they would all happen at the same time. Prosecutors asked Mr. Alessi about the instructions Miss Maxwell gave to the staff, and Mr. Alessi recalled that she said that Mr. Epstein doesn't like to be looked at in the eyes. You should never look at his eyes. Look at another part of the room and answer him. Mr. Alessi revealed that the Duke of York, That's right. Prince Andrew visited the man named Jeff's mansion in Palm Beach, Florida, 2 or 3 times while he was there under the employment of that guy named Jeff. He recalls Prince Andrew was the only guest to tip. That's right. Only guest to tip the staff. Now, I don't know how that works. I personally like to tip. But I guess when you have the maid and the staff, I think you probably ask the house people, should I tip them or is that just part of the job? I don't know, but at least Prince Andrew, given all of his alleged flaws, at least he was taking care of the staff. We'll see how things are going. Like I said yesterday, courtroom observers are not exactly impressed with the performance of the prosecutors, and they seem to be throwing around a lot of individuals' names. But guess what? They have to prove that she, Miss Maxwell, knew what was going to take place. Maybe she was just as wide-eyed at the lifestyle that she was living and didn't know exactly what was going on behind closed doors. We'll have to wait and see what the jury will decide. We have several more weeks of testimony, but usually the prosecution starts off with a little bit more of a bang than we've seen thus far in the trial. That's all we have for you today. Thanks for watching. We'll see you next time on Crime Talk.